डिस्ट्रिक्ट कोर्ट में जब थे तो ऑर्डर जो पास करते थे दो डेट लिखते थे, सपोज 5/12, उसके नीचे एक डैश करते, उसका क्या मतलब है?
Similarly, if this was successful, it would be heard on subject, then date of very
ऐसा प्रैक्टिस है?
जी
ऐसा प्रैक्टिस है बिना बिना रिकॉर्ड किए हुए कि ऐसा होता है? मैंने हम आपसे जानकारी उसी पर हमने रिकॉर्ड्स में आया। देखिए ऑर्डर पड़ा मेरा,
कोर्ट नहीं तो दूसरे डेट ऑफ वेरी
हमने रिकॉर्ड्स बनाया है। डेट सही है।
I have flagged both the dates, Your Lordship.
Well, that's right. That's right. Let me take advantage of the experience of my brother judge
Yes.
before district courts.
100 दिन का ऑर्डर है और 20 रूल 1 में कोलैप्स कर जाए। CBC under 20 rule 1 says that in any how of the matter within 60 days the judgment has to be pronounced or it has to be re-notified for hearing. It has not been done.
That date could not be heard, hence it was heard on
रिकॉर्ड कुछ नहीं करना
होना चाहिए,
Special है,
लेकिन
CPC
नहीं होना चाहिए।
आप करते थे?
आप 2.3
लोग के मुंह करना नहीं होना चाहिए।
हाँ बताइए। Yes, Mr. Sanjay Kumar, what were you saying?
Lord,
moreover,
Lord,
only
I have demonstrated before my Lord that the order is antedating only because Annexure 2 has been passed on 15/11/2021. Lord, may kindly see Annexure 2, page 37. When the Honorable Court directed the district magistrate to pass the order within 6 weeks after giving the opportunity of hearing to the petitioner, on the subsequent date it has been passed as if he was hearing the matter. No, my Lord, I have already demonstrated before my Lord that order was date fixed for date 5/2/2021. Thereafter, only by slashing the date of order 16/11/2020, the order has been passed. But as per CPC Note Order 20 Rule 1, the judgment has been reserved, then it has to be passed in any how of the matter within 60 days.
CPC दे।
Lord, Order 20 Rule 1.
छुट्टियों का दिक्कत करता है, वासी का छुट्टियों का वासी करता है। अपन क्या करें, सामान्य केसेस में आता है
आप यो दिखा रहे हैं ना?
और some
You are demonstrating.
there is no hearing of such date on count of declaration of that day as a holiday. So they take up on next day, say then slash. But they are the regular person. They don't make the party know when that will pass on, or in case they pass on it, they don't. In fact, they have not passed out of that date. Antidote order दे करके subsequently pass करता है।
नहीं 5 तारीख को ऑर्डर रिजर्व हुआ ही नहीं था।
Order 20 Rule 1. May I read, my Lord?
Which section? Which rule?
ऑर्डर 20 रूल 1 ऐसे ही है।
CPC ले आए, CPC और EC दोनों ले।
वही जो हम पूछ रहे हैं आपसे। Have you preferred an appeal against the order?
No, my Lord. I have
Why?
filed this petition because the order is antedating, my Lord. As per Annexure 2, which was passed on 15/11/2021, my Lord, at page 31, 38, my Lord, subsequent page, my Lord. Since we filed the writ petition in 2018, when the consideration which was not disposed of, my Lord, thereafter this order has been passed. That we find that there has been an inordinate delay on the part of the collector Darbhanga in disposing of the aforesaid confiscation case number 102/2018. However,
Just a minute. ये 5/2/2021 को विपक्षी की ओर से हाजिरी अपराध वादी का विद्वान विशेष लोकपदियोजक उपस्थित। हाँ ठीक है, 5/2 हो गया। तो उस दिन एक डेट देगा ना कि फलाना डेट के लिए रखा, दिनांक 25 को
फ्लैग कर दिया।
ये यहाँ पर रखा नहीं।
Should give a date. Next
यहाँ
date.
तो रखा नहीं।
को सब दे चुके।
तो फिर यहाँ पर इसको बनाने की क्या जरूरत है? 5 को उसी डेट में
ये
क्यों
गलत है,
करें?
ये गलत है कि जिस पर एग्जाम्पल केस माइट
ये तो एंटीडेटेड नहीं हुआ होगा, उसका डेट नहीं सामने में दिया।
विदाउट इंटेंट दे हैव
नहीं, यहाँ देखिए ऐसे ही कर रहा है। 26 के बाद 21 साल।
सब गलत है। जैसे यहाँ पे जाने 74 पाल लिखा है, 26 ठीक है, 26 है,
26
हाई ठीक है,
न्यायालय का बाधित हो गया तो 26 के बाद 21 7 रखा, फिर 8 9 रखा, फिर 20 10 रखा, फिर 11 12 रखा, फिर 5 को।
इसको इस दिन जो 5 नहीं लिखा है, डेट देना चाहिए कि उसको
हाँ, तो मैंने ये एंटी डेटिंग का केस बन नहीं रहा है, गलती है, मिस्टेक है इन ड्राइंग ऑफ द फाइल्स।
2/6/20
एक लाइन नहीं लिखाने के कारण ये सब होता है।
So without giving permission to the party, they have passed the order.
नहीं, वो
इसका डेट नहीं है ना इसके बाद?
नहीं, इसके बाद
डेट का
Court is also under an obligation to tell you why we are not taking it as anti-dating. Now there is some sort of irregularity in maintaining the file, but we see that the matter was first listed on, I mean, at one point of time it was listed on 17/4/2020, when there is an endorsement that कोरोना वायरस के कारण कार्यालय काम स्थगित, दिनांक 2/6/2002 को रखे हैं, 2/6/2020 को रखे हैं। अब 2/6/2020 को भी इन्होंने लिखा है कि कोरोना वायरस के कारण न्यायिक कार्य बाधित, और उसके बाद लगातार डेट दिया है उन्होंने 21/7/8/9/2021 और उसके बाद 5/2/2021 के बाद 16/11/2021 लिखा है। अब क्वेश्चन ये है, यू राइट, you can argue this, but we are not accepting this for the moment for 3 reasons. Number one, if the court has passed an order on 15/11/2021 giving window to the court to pass a final order, there was no great fun in overreaching the order of the court and passing an order otherwise, because otherwise also, now suppose the court would have said that if it is found that the order has not been passed by this date, the court below shall afford to the petitioner an amount of ₹50,000 as compensation. Then perhaps it could have been understood that in order to avoid making payment of that compensation amount, it would have been antedated. But here we find that the records have not been properly dated, but we don't find any reason to penalize them.
No, at least the matter should be remanded for hearing. After giving hearing to me, he can pass you the fresh order. What did he change that? Not, I will not say, but out of the record, not, I can say it with my guts that this has been done only at the instance of the counsel who was representing the state on that date before the division bench. I can say this because the honorable court has directed him to seek instruction, and that is why this has been communicated that you have 50,000 costs imposed upon you if you will not pass any order.
Mr. Sanjay Kumar, you have put in more than 20 years of practice. Now we would not expect you to speak anything against your own colleague in court about whom you do not know. Now this is your presumption. You are making
I had represented the patient in that case also. That is why I am aware of the fact.
That's right. So therefore, this could be a circumstance which can give you a feeling in your mind that perhaps this has been at the instance of the lawyer. But the lawyer is not an interested party here.
Lord, then why it was not on 17, 18, why it is only on 16?
That's all right, but see, you have a right to argue and you have rightly represented
no,
this.
I have demonstrated before, Lord.
That's all right. We don't take it to, that's right, Mr. Sanjay Kumar, we don't take it to that level now. Now you argue afresh on the merits of the case. Now this writ petition has been filed for what?
Not for questioning to order, not which has been passed by the collector. For confiscating the right to not, it was 41.
Now therefore we direct that the order shall not be given effect to till the time the appeal against the order of confiscation is not decided. Go before the appellate authority, the district judge, who shall decide the matter. Since there is a provision and you have read the Supreme Court judgment only 2 weeks ago,
the 6C I have to file the appeal. But only because the...
Yeah, that's all right. All right, it's good that you have brought this to the notice of the court. Now, the officers also will be careful in fixing dates. Now, we are recording it.
I hope so.
We are recording it. That's, I think you have done your job as a counsel, not only counsel for the party, but as a counsel to ensure that these anti-dating of the orders are not resorted to generally. So, we will be recording something in our order. That way you have been successful. But then you prefer an appeal, and till the time the appeal is disposed of or any interim order is passed, this order shall not be given effect to. That's what we have decided. All right? Be careful.
Some time may be fixed, not because the party is kept in the custody since 2017 December.
We'll say that.
Might have.
We'll say that.
That is a perishable item, Lord.
We'll say that.
Your Lordships may kindly see, he has approached this honorable court for release of tractor, not for that party.
Rice also. For tractor and rice also.
Release of
In any case, whatever has been auctioned,
जी.
whatever has been directed to be auction sold,
If it has not already been auction sold, Your Honor.
actually, otherwise, then what is the provision? You see,
IL
if it has been sold, then you have to quantify that amount, you have to return it to him. If the seizure is found to be
That is there.
bad, 6A or 17, वो क्या है?
6.
Anyway, whatever is the provision. लिखिए, the pursuant to the order passed by this court on 13/4/2022, the original records of the court of the district magistrate was produced by the counsel for the state. It appears from the records that the matter had been coming before the court since 17/4/2020, on which date, because of the spread of corona virus, the court could not be held. First off, similar was the situation on next dates, namely 2/6/2020, 21/7/2020, 8/9/2020, 20/10/2020, and 11/12/2020. First off, the case was finally fixed for hearing on 5/2/2021. First off, thereafter, a bench of this court passed an order. Where is the High Court's order?
Next year
Lecture
2,
2 will not page 35, 37.
page 37. PY2.
Thereafter, a bench of this court passed an order on 15/11/2021 directing the Collector Darbhanga to dispose of the confiscation case number 102 of 2018, failing which, dispose of within a period of 6 weeks, failing which the state would be held liable to pay a cost of rupees 50,000 to the petitioner, and the same would be recoverable from the concerned officials responsible for the delay in disposing of the said case. It is quite fortuitous that an order was passed by the collector on the next day, that is on 16/11/2021 only, giving an impression to the petitioner that the order has been passed in anger by antedating the proceedings. It is only to find out the correct facts that this court had called for the records, original records of the court of the collector. Though on the dates when the records are placed before an officer, there should be an endorsement with respect to another date, but we have found that on several dates such endorsements were not made. Thus, it is difficult for us to accept the charge that in the present case the order has been passed by antedating the proceedings. Otherwise also, this court has nothing, this court is not possessed with any wherewithals to decide that the order has been passed in anger and in order to overreach the order passed by the division bench of this court. Be that as it may, since the matter has been brought to our notice regarding irregular manner in which dates are given in the cases, we deem it appropriate to direct the authorities, especially the collector Darbhanga, to maintain the records appropriately by fixing dates. Otherwise, it can always be charged that some order or the other has been passed antedating the proceedings. We further find that the order passed by the collector Darbhanga has not been put to challenge by the petitioner. Under the circumstances of this case, we are of the considered view that in case the petitioner prefers an appeal against the order of confiscation of the tractor of the petitioner as also the food grains loaded on it, which was seized along with the vehicle, the appellate authority, namely the district judge, shall take up the matter at once and shall dispose of the appeal positively within a period of 30 days from the presentation of the memo of appeal. First up, the aforesaid time frame has been provided by us, taking into account that for a long time food grains which has smaller shelf life has been lying in the godown of the collectorate. Lying in the godown of the collectorate. With the, till the time the appeal is not decided, the order of the collector order the collector to auction sell the vehicle as well as the food grains be put in abeyance. First up, it is expected that the appellate authority shall maintain the time frame provided by this court. With the aforesaid direction, this writ petition stands disposed of.
A further caution to the petitioner to not take unnecessary delay, Your Lordship's on.
Otherwise he is responsible, otherwise not. You have kept it for 3 years. That we have not 5 years that we have not done anything to you because we find that this is the irregular manner in which you keep your records, and there is nothing. I mean, we don't have the wherewithals to say what are you doing, but we see day in day out how collectors are functioning.
Your order 20 rule 1 अगर ले लेंगे नोटिस में तो इनको बहुत मुश्किल हो जाएगा.